but we'll use this time to give Judge Makhubele an opportunity to present her side of the story, but also for me to put certain questions to her. The contemplation is that there will still be another day when an evidence leader can put questions to Judge Makhubele once I have either decided on the so-called recusal application, or if I have decided or found somebody who can lead the evidence for practical purposes. So that is why Mr. Soni is not at the podium today, but he is here, and I will call upon him to assist me with regard to finding certain documents that I might need at a certain stage, because he and his junior are maybe quite familiar with the location of various documents in the bundle. So there will be two parts. One, I will allow Judge Makhubele the opportunity to tell her side of the story to a very large extent. I will not be asking her questions during that time. I'm going to limit that to 30 minutes, and she has indicated that she's happy with that allocation of time. And thereafter, I will put questions to her, and then she will deal with the questions that I will put to her. I think for the purposes of refreshing the memories of the public and whoever may be listening, it's important to say that Judge Makhubele's evidence falls under the investigation that the Commission is doing in regard to various allegations of corruption and acts of state capture at PRASA. And Ms. Martha Ngoye, who is head of the legal department at PRASA, as well as Mr. Dingiswayo, who is also in the same department at PRASA, gave evidence on a number of matters, but their evidence also included what they said was the role played by Judge Makhubele when she was chairperson of the board of PRASA from towards the end of 2017 to about towards the end of March or mid-March 2018 when she resigned. The part of the allegations they made was that Judge Makhubele came to PRASA and had a special interest in the settling of certain cases which had been brought by certain companies falling under a group of companies called CIA Group. That company had allegedly entered into certain contracts with PRASA, and according to it, or according to those companies, they had performed certain services for PRASA, and PRASA had failed to pay them when it was obliged to do so. And those matters had been lodged in court, and PRASA had filed its defenses, its pleas, but ultimately there was an agreement that the matters should go to arbitration, and they were going to be arbitrated. So Ms. Ngoye testified that after Judge Makhubele had started being chairperson of the board of PRASA, she insisted that the claims by those specific entities of falling under CIA should be settled, and that her department was excluded. And Mr. Dingiswayo testified that on the 15th of December 2017, he phoned the attorneys who represented PRASA in those arbitration proceedings, Mukhashwa attorneys, in order to discuss the matter, but was told by Mr. Mukhashwa that the chairperson of the board, that is Judge Makhubele, had instructed that the attorneys should not speak to the legal department of PRASA about those matters. The long and short of it is that the matters were settled, and the allegations that the attorneys for CIA Group got information that came from the chairperson of PRASA, Judge Makhubele, that would not be expected to have been sent to the other side. And there was a question of how it had come about that PRASA's opponents in the litigation or in the arbitration got information that they should not have got. In particular, it was information about how PRASA's attorneys had been instructed to settle the matters. After the matters had been settled, CIA's lawyers and PRASA's lawyers made arrangements in terms of which they appeared before the arbitrator, who is a retired judge, and the settlement agreement was made in order of court, so awards were made which required PRASA to make payments to the CIA Group, and the amounts altogether appear to have been in the region of about 59 million that PRASA had to pay. There was also interest that was supposed to be paid. And when PRASA did not pay those amounts, the CIA Group of companies approached the court to make the arbitration awards an order of court. By that time, the legal department of PRASA had been in touch with the newly appointed Minister of Transport, Dr. Nzimande, and had told him what they believed was happening and the role that they believed Judge Makhubele had played, and he had instructed that the legal department should take steps to try and, in effect, reverse that process. So the arbitration awards had been made orders of court, but subsequently a rescission application was made and those were rescinded. But the legal department had also to bring an interdict application, urgent interdict application, to prevent the sheriff from paying over millions of PRASA's money to the CIA group, because in the meantime, the CIA group had attached money in PRASA's bank account. So Ms. Ngoye and her department instructed another law firm, Bowman's, in order to assist with regard to that. Also their evidence was to the effect that there was some drama in court, because when counsel briefed by Bowman's sought to oppose, it was found that counsel for CIA Group was able to show the judge a message that had been received, according to them, from Judge Makhubele, which said that the lawyers representing PRASA, which sought to oppose the CIA Group's application, had no authority to do so, and the judge had ultimately accepted that and granted the order. But ultimately, the rescission application that was brought by PRASA was successful, and those amounts were not paid over. So I thought I would summarize the gist of the evidence given by them. There are other details, but just to refresh the memory of the public so that also they can understand this evening's evidence in its proper context. As I said, what I will do after Judge Makhubele has taken the oath, I will give her about 30 minutes to tell her side of the story. And after 30 minutes, I will then ask her questions. Please administer the oath or affirmation.
Please state your full names for the record.
Inshallah, Anna Makhubele.
Do you have any objection to taking the prescribed oath?
None.
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that the evidence will give will be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
Help me God.
Thank you very much, Judge Makhubele. You now have 30 minutes to tell your side of the story.
Thank you, Chairperson. Before that, I think I need to place on record the issues about the documents that I was provided on Monday. They are behind me, so maybe for 2 minutes, if I can deal with that.
Yes, I think somebody can help you to bring them to you. Somebody will bring them to you in front of you.
I don't know what's the best way to deal with them.
Or
But
they might
what
put
I
them.
wanted to say, maybe because they were handed over to me in a hurry, there's a one bundle which,
Well, I can tell you that the way to distinguish them, you should look at the spine of each one. Each one is supposed to be written bundle 1 or bundle 2 or bundle 3. each one of them?
No, I have. What I want to say is there's one bundle which contains the documents of one Lucky Montana, nothing to do with me at all.
Oh,
So I
okay.
just want to say,
Yes,
it's a whole file.
yeah, they
So
can
when you
take that
miss
away.
documents, you mustn't say, I came and stole Lucky Montana's documents. Maybe
Yeah, no, I
if
think
they
you must,
can be removed from
it can be removed from
my
there.
side.
Yes. Ms. Rangata, look for that one and take it away.
It says additional documents. These are all Lucky Montana's documents. My story, Chair, is in the bundle where I responded to Advocate Bote's affidavit.
I'm sorry, I was giving my registrar a message here. Just start afresh, please.
I'm told it's bundle J.
And that is the one that has got Mr. Porter's affidavit and your affidavit as well.
Yes, there's an attachment in my response to Advocate Bote's
Yes.
affidavit. It's a statement of referral of a complaint to the Pretoria Bar.
Yes.
I'm not sure if it has been paginated.
Well, I've seen it, I've read it, so I'm sure it is here. It is,
It is, the pagination is the red stamp.
actually, normally we use the red, but I think where you see the red and the black, follow the black one at the, it's rather top left of each page. Mr. Soni, that is correct, eh?
I think it's, the flag is, there are so many flags, same numbers, but I see.
Well, I see,
SS19 TAM-46.
yes, when you refer to the page, then you can leave out SS19 and TAM and the 0. You can just say 43 if it's
45.
Yeah, is it 45?
So that's 45.
Oh, but that is red. Let's try, what is the black number?
The black, I don't know whether it's me who marked the BB.
Hang on, I think I'm going to find 45 now.
Oh, the black is 147.
Just switch on your mic from there, Mr. Soni.
Page 146.
140, the black 146. Okay, page 146. Okay, I've got that. But that's the last page. What page does it start? Can you find it, Judge Makhubele?
It's 147.
It starts at,
It starts at 147.
147. Oh, okay.
Yes,
Or your statement of referral. Yeah.
yes.
Yeah, okay, page 147. That is the black 147.
Yes, Chair, remember I said I haven't provided a sworn statement. I'm still going to do that.
Yeah, okay.
But
Okay.
the essence of the statement is what's in here.
Okay.
And as I indicated, I will have to make certain additions
Yeah.
based on the oral testimony of Ms. Ngoye and Mr. Dingiswayo, which I have not considered. I have been given transcripts yesterday at night. I think around 7 or 8. So from what I could quickly glean out, I need to file a proper sworn statement.
Okay.
So
okay.
today, Chair, the 30 minutes may not even be enough to deal with the main evidence or allegations against me are by Ms. Ngoye. So
Yeah.
I will still deal with Mr. Mukhasha, Mr. Botes,
Yes.
Mr. Ahmad,
Okay.
and Mr. Madinte.
Well, let's see how much you have been able to cover by 30 minutes and take it from there.
Well, the other thing, remember, Chair, now I'm attorney and client.
Yeah.
And
And counsel.
and counsel and everything. And yesterday I wrote a letter, which I don't even think it has reached you, because I wanted to understand exactly what are the allegations here that you are investigating. Because remember, everything comes from the affidavit that Ms. Ngoye filed at Pretoria High Court, and which I have here. So there's the same complainants here filed a complaint at the JCC, but they've added other things, which I want to be certain that here,
Well, here, you are expected to deal with the witnesses' affidavits as filed here.
as filed here.
As filed here, yes.
Yes,
Yeah.
because
Which you have got.
there's confusion even in the public domain that there are so many allegations, nothing to do with the settlement of CIR claims, which I believe that's what I must respond to here before you, Chairperson.
Yeah. No, for our purposes, you look at the affidavits that they have filed here,
Yes,
which have been given to you.
thank you. In this statement 148, 147, I have summarized. I wrote this statement with reference to the affidavit that Ms. Ngoye filed dated 3 April 2018 in the application where PRASA was seeking to interdict the sheriff from executing the writ. So this statement is an answer basically to this affidavit. I see there are complaints here, they tried to abridge it a bit, but here I dealt with the circumstances under which those claims were settled. And basically, I denied that, let me start here. I had an opportunity yesterday to look at Ms. Ngoye's complete affidavit that she has filed here, dealing with everyone and every issue. And I made notes because I was asking myself, what exactly is her role and what is she saying? And I see she says in paragraph 7 of the affidavit before you, Chair, that the leaders in PRASA have been found wanting in various reports. She referred to the reports of the Auditor General, Public Protector, National Treasury, and in paragraph 25, talking about CIR matters, she said that it's not her intention to persuade this commission about the merits of PRASA's contentions, but she just wants to show the length, often improper, to which people at PRASA went out to ensure that PRASA pays money that's not due. And one of those people that she describes I believe it is me, and that's where it starts. So, firstly, I deny that I am one of the people who have been found wanting in any report of the, be it the AG, National Treasury, Public Protector, or any court of law. So I am not one of those people. There's no one who has ever found me guilty or made any findings against me in relation to wrongdoings at PRASA. That's the first statement I am making, Chairperson. And secondly, I deny because she might have diluted her initial evidence, but the initial evidence in the affidavit before court was that the settlements were done in secrecy. The legal section which she was heading was not consulted, and actually no one was consulted, and that was the basis for her complaint. And most importantly, that the settlement was done in furtherance of what she refers to as a questionable relationship between me and the lawyers who were representing Siaya in the liquidation application. So in this, Chairperson, I highlight the circumstances. I will not deal with how I was appointed to the PRASA board, but I will deal with where the circumstances under which the claim were settled, and it starts at paragraph 9 of this statement. That will be your page 151.
Yes, okay, that is page 151 of 1J. Yes, you may continue.
Paragraph 9 with its subparagraphs, and there are annexures, Chairperson, which unfortunately, I did send the annexures to the legal team, but I see they have not been paginated.
Yes, no, but because there is the overall pagination, which is the black numbers at the
Yes.
top. You can use that, but with reference to your own statement, you have numbered the paragraphs.
Yes.
So you can refer to the paragraph numbers as well.
Well, when I use the word paginated, I mean the annexures are not part of the record.
Oh, okay.
So Chairperson will not be able today to see the documents I'm referring to. For instance, when I say the liquidators approached me, first through Advocate Botes, and then they wrote a letter to me, Chairperson will not be able to see that letter because I don't know if it's part of, yes, this,
Well,
the letter,
I've
at least
got-
the
I've got
letter,
some annexures.
the letter is part,
Yeah.
but there's a lot which are not part, but there's a few that are parts, but when I come back, Chairperson, I think we'll have all the annexures, but the letter of the liquidators is in.
Well,
it's,
if you do have those annexures which are not here in your possession at the moment, there may be an opportunity for copies to be made. But if you don't have them, then next time we can look at them. Do you have them by any chance with you?
Well, I don't know. I did send them to Ms. Rangata, but I don't know if she compiled a bundle of those.
Oh, let me ask Mr. Soni, Do you know about any other annexures to a statement referring the complaint to the Bar Council? It may be that they were not included because they might not have been seen as relevant for our purposes. Yes,
That, given the limited nature of the allegation,
yes,
and this was an allegation against Mr. Bolton,
yes.
we try to restrict the
To
matters
what you
what
consider to be
statement is.
important. But would they be available within the legal team? So I guess they would be available, even if not here.
I'm sure they would be available.
Yes. Okay. I think arrangements will be made if you think they are relevant. As Mr. Soni says, they try to say, look, what's really important for purposes of the Commission's own investigation as
Yes.
opposed to the Bar Council's investigation. But if you think they are relevant, they can be obtained. So for next time, you can refer to them.
Well, for my purpose, they are relevant because those are internal PRASA documents.
Yeah,
I see Ms. Ngoye and Mr. Dingiswayo only attached my memorandum,
yeah,
but then there are documents that were generated within the board and from the secretariat
yeah,
relating to what I'm talking about here. For instance, I will need to refer to the Delegation of Authority, which chairperson obviously needs to see. And the relevance of that document is that I saw Ms. Ngoye attached a Delegation of Authority, but my submission is that's not what was given to the board. And I have proof of what was given to the board. So everything that I've sent is relevant, but I will ensure that I compile the bundle myself.
Okay, that's
and,
fine.
And when I give a
For
sworn
next time.
statement.
okay, all right.
But in the first few paragraphs, I deal with the approaches. And you will remember, Chair, that there was an issue between me, Mr. Botes came here and testified that I called him, and then our phones were subjected to investigations. There's a report from the investigator, it's part of the bundles here. So, Chair, that matter must be settled. The report of the investigator shows that, obviously he can't say it with certainty, but he says it's probable based on what he has analyzed. It's probable that Advocate Botes is the one who contacted me first.
First.
Yes,
Okay.
remember he came here and made a lot of noise that I called him. So that issue, Chair, you will be referred to the relevant report that it's settled. He's the one who called me.
Yes, no, he did testify that you called her first.
You called
And,
him, yes.
Yeah,
Yes, there's a report from the investigator here that should settle the issue unless Advocate
Yes.
Botes would like to take it further.
yes, I think what the Commission's legal team or investigators will do is, if they haven't already done, is to make that report available to him for his comments.
Yes.
And you will be informed or send a copy of his comments as well.
So for now, I stand by my paragraph 9.1 that he called me first in the week, I said in the second week of November 2017, followed by a letter. The letter is from his attorneys. And then Advocate Botes came in person to PRASA because I said to him, I cannot discuss with him anywhere else other than at PRASA. At the time, I was still a member of the bar, so my chambers were still open. But I said, let's meet at PRASA than anywhere because as far as I'm concerned, what you are telling me requires a transparent engagement involving everyone, including my colleagues at the board and the then acting group secretary, who is Mr. Zide. He then came, the date was, I think in my statement I say 13, but looking at my notes, the date there should be,
Was it not the 14th?
it's 14th.
Yeah,
Yes.
14th
So
of
the
November,
date is
2017.
14th November. He found me with Mr. Zide because on that day I was in several meetings. That's why I was at Prasa. I said to him, when he comes, I'll take time off and talk to him. But by the time he came, he had already told me what it was all about, which was basically what is in the email exchange between him and Mr. Madimpe Mukhashwa, that the parties were involved in litigation. There were those claims, several case numbers, but which were then consolidated because there's an arbitration clause. My understanding is it was not simply that they agreed to go on arbitration. There's an arbitration clause. Prasa took a point that you cannot proceed by way of action because there's an arbitration clause. And then there was an agreement to withdraw and go to arbitration. And in the meantime, as Chair, I don't know, I can't remember if Chair has summarized this, but then in the meantime, the part of the claimants went on voluntary liquidation, and then there was an application to court to appoint a commissioner to conduct to conduct an inquiry. The inquiry, when I went to Prasa, had already been concluded. There was an interim report of the commissioner. His name is Mr. Kreche. He had issued an interim report. So when Mr. Botes came to Prasa, he came with that interim report and correspondence between him and Mr. Madimpe Mukhashwa. I don't have a lawyer next to me, Chairperson. I wanted to refer you
To the report.
to the report.
Yes, well, Mr. Soni is able to assist.
The report of the
liquidator.
of the, not liquidator,
Of the
of the
commissioner.
commissioner.
Yeah.
It's
What is the page? Where
it's in
can
the
I find it?
statement of Mr. Botes.
Just hang on, Mr. Soni might be able to just tell us what page to find it.
It's page 28 as an annexure to Mr.
What
Botes',
volume first? What bundle first?
sorry, bundle J, Chairperson.
Bundle J and what
Page
black number?
28, it's only red numbers.
Oh, okay. What is where do we find it?
It's page 28.
Yes, I found it. In my bundle, it's J, the black number is J/-065, the red number is 28.
Okay. Mr. Son, you said it's page 20,
Page 28 on the right-hand side, the red.
the red one.
Yes.
Oh, we need to be consistent if we use the black ones. You said there was no black number on the page.
On my, but apparently yours has it, and
Oh, yeah,
if
mine
I can
does
just
have.
explain what happened here.
Yeah.
The bundles were prepared with Judge Makhubele's complaint put at the top.
Oh,
And so the pages had to be renumbered because
Okay.
Mr. Boltis gave evidence first.
yes, okay,
So
no, that's fine.
that's why the
Yes.
number. And then what we did is we took Judge Makhubele's complaint, which he has been referring to,
Yes.
and we put it as part of the affidavit.
Yes, no, that's fine. The Commissioner's interim report is at page 65 in terms of the black numbers. Yes, Judge Makhubele, we are there.
Are you there, Chairperson?
Yes, I've got it.
Yes, so that's the Commissioner's interim report of the inquiry in terms of section 4171 and 4182 of the Companies Act 61 of 1973, read with item 9, Schedule 5 of the Companies Act 71 of 2008, and it gives a brief summary of the evidence that he explains in paragraph 1 his appointment and the company resolution, and that he has had an inquiry on 28 and 31 August 2017, and then paragraph 3, who was representing who? Mr. Botes was representing,
Well, I think you might wish to just go straight to the real
To the
issues
real
you want
issues.
to draw my attention to.
Yes.
The other stuff I can read for
yes,
myself. Yeah.
maybe paragraph, the representation for PRASA is indicated as the head counsel, Mr. Tsatawani, and the instructing attorney was Mr. Madimbe. The witnesses, Chairperson, are in paragraph 4. It's, there are 6 witnesses. The relevance of this paragraph is because I mentioned somewhere that I consulted with these witnesses. And these are the witnesses who were still employed at PRASA. And that will be your Mr. S. Baltic and Mr. Obue 4.4. And then there are those who had been issued with subpoenas but not yet appeared. I think there are, I will talk about them. Maybe there are 2 or 3, but in this list, the ones that were still at PRASA is Mr. Baltak and the one in 4.4. So I never had any consultation or dealings with people who were no longer at PRASA. That's the point I want to make. And then the summary of the evidence of each witness. I am not sure if Chairperson has already has this evidence on record, so that I don't repeat it, but maybe.
No, you can make what you consider to be the important features
Yes.
of what he says for your case.
Then maybe only the witnesses that I consulted with, the evidence of Mr. Soren Baltic. Mr. Soren Baltic, in addition to this, wrote a report to me, which I will give Chairperson. I saw it somewhere in the annexures in the court application, but I don't think it has been annexed in the documents before you. So in addition to this, Mr. Baltic also provided a report, and his evidence, he was asked to testify. He says he is a general manager, signaling and telecommunication, and he was asked to testify about the project indicated the technical assistance for supervision of National Resignaling Project Stage 1, phases 1 to 5 agreement, and then he confirmed the agreement entered into between PRASA and the company in liquidation on the 31st of May 2011, and indicates the amount, just above 54 million. He confirmed he was personally involved and had personal knowledge of the way the contract was implemented and executed. The reason I want this on record, Chair, is because the issues raised are that I said there were concessions by the witnesses.
Yes.
So that's not me. It's what the report is saying.
Yes.
And
No, I think what, I think my understanding is that what has been said is that you said that in terms of the interim report, it is said that they made major concessions. I thought that was what was said, but you can deal with it and respond to it. If you never said, if all you said was, I'm relying on the report because it said they had made major concessions, that's fine.
well, when you can use the word measure or concessions, the amount would probably not be really an issue, Chair, because what is being contended is that the witnesses never considered anything. So it's when issues of concession are being made, it's something very strange. But you know, English is not my first language. But when I see the word confirm, and then I also consult with the very same person and ask him, look at this report. They say this is what you told the commissioner. Did you really tell the commissioner what is written here? And the person says, yes, that's what I said. And a person writes even a separate report to you saying, yes, that's what I said. And I'm not talking about an illiterate who, let me not use the word illiterate. I'm not talking about a person who is not literate, who may say, maybe the report was not, I don't know what's written, it's not what I said, but it's a person that actually confirms what's in this report, Chairperson. So I will give you Mr. Soni's separate statement from this, what the commissioner has written, as well as after I've transcribed my notes, that these are the dates. But to me, these are concessions, whether you want to classify them as major, minor, but they go to the heart of the issues that he was asked to deal with. So,
Well, I was looking at paragraph 5, where it talks about Mr. Baltic, 5.1.7, at page 67, if you look at the black numbers. Is that where you are as well?
he testified about two.
Because I thought you were talking about Mr. Baltic's.
Yes, he starts at page 29, the bottom of 29.
Yes.
It's
Well, it says that 5.1.2, Mr. Baltic confirmed that he was familiar with the above agreement, which was entered into and concluded between PRASA and the company in liquidation on the 31st of May 2011, which was for technical assistance for the supervision of National Resignaling Project Stage 1, phases 1 to 5, and that the value of the contract was 54,537,600 rand. And then 5.1.3, he further confirmed that he was personally involved and had personal knowledge of the way the contract was implemented and executed, and that according to his knowledge, the company had complied with the conditions of the contract. Mr. Baltic also said that he had no reason to believe that the company had not complied with the terms of the contract. According to the company, the amount outstanding in terms of the contract is 15,319,491 rand 61 cents. Mr. Baltic could not confirm or deny that this figure was accurate and agreed to consult PRASA's records to confirm what was due in terms of the contract, and then revert back to the liquidators and the commission with the correct amount. On the 8th of September 27, I received a letter from PRASA's attorneys in which they said that their clients were investigating the matter and that they would, as soon as possible, make their findings available to the commission.
Yes, so subsequent to this, the report that I will give chairperson, which Mr. Mokhashwa also acknowledged having received, was Mr. Baltak was reporting back to the commission, to the commissioner, to say, remember in that paragraph, the only 5.1.5, the only issue was the amount, which he said he was tasked to go and investigate the amount of the invoice. Then in the report that I will give chairperson, he was confirming that he has made investigations, and then the amount, the correct amount is this, and I think it's less than this 15 million, if my memory serves me well. So his task was to confirm the amount, because the claim was for 15 million and Mr. Sonic was not certain, and then he came back with a report that said, no, it's not 15 million, it's less than that. So that's with regard to this agreement. And then he also testified about the other agreement. It's titled Consultancy Agreement for Technical Advisor for the new Digital Railway Signaling Radio Network, contract number HO-infra brackets T and 301/01/2013. In the summons, in the pleadings, you will see which claim relates to which contract. There's a contract number.
Yes.
And that's how they are identified. So he also he testified, and then 5.1.8, he was familiar with the agreement. And according to my understanding, he was someone you can call the supervisor, or when during implementation stage, you will be the person overseeing the work. And then 5.1.8, the commissioner says it appears the amount due in respect of agreement would not be agreed upon by the parties to the contract. So the company represented by Mabunda in its former CEO and Mr. Baltic agreed to meet to try and calculate the amount which is due and payable to the company, and to submit their answer to the commission and the liquidators by 11 September 2017. And then the next page, 5.1.9, on the 6th of September, the commissioner received a letter by email from PRASA's attorneys addressed to the commissioner and the liquidators representative, Mr. Boshoff, in which they confirmed that their client, Mr. Baltic, was requested to engage with Mr. Mabunda to calculate the amount which was due in terms of the contract, that number. So you can see there, Chairperson, that the parties are in agreement about what outstanding issues they must still investigate. And I will look in my records, but I think this letter is in some bundle. So that was the issue. And in the aforesaid letter, they say that the contract was with a company called CIA Rail Solutions and not with CIA Consulting Engineers, the company which is the subject of the Commission of Inquiry. Accordingly, they say that it's not clear why their client has been called to testify about the affairs of CIA, which has no links with company which is the subject of the inquiry. In the circumstances, it would, in my view, be appropriate to have the contents of the aforesaid letter raised before the commission when it commences. Chairperson will see later on that there were some claims which were not settled. One, if I remember, was because it was not part of the liquidation inquiry or insolvency inquiry. And the other one that was not settled was because there were outstanding issues that could not be resolved. And I think it's a claim that involved the witnesses that I said were no longer at Brasa. Mr. Montana, Mr. Makhubele, and I think so. That claim was not settled for the simple reason that there were issues that no one.
I see 30 minutes has expired, but I'll allow you a little bit more time to continue, and then I'll start asking you questions.
Chairperson,
So I will allow you
do you intend to adjourn what time?
I would like us to continue and see how far we have gone by 7, but I think we won't leave before 7. So we might go to 8.
This Chairperson, although I said the issues I diverted from that statement to deal with the evidence.
Yeah.
But
Well, when I ask you questions, some of the issues you'll be able to deal with.
yes,
Yes, but I'll let you continue now for another 10 minutes.
so that's Mr. Baltic. And the next one is I think it testifies again somewhere, but maybe the best place where I can tell Chairperson for certainty is when I read some of, maybe let's go to the page 35.
We are looking at the red numbers. Eh?
The red number, that's
Okay.
that's Mr. Kobiwe.
That's page 72 on the black numbers, 35 on the red numbers, yes. You want to draw to my attention there?
The evidence of Mr. Kobiwe is paragraph 5.4.
Yes.
We sat with this witness for a very long time, trying to unpack the issues here. And if Chair can allow me, I will deal with it in my statement.
Okay, that's
So
fine.
maybe I can leave this for now, the report, but the next document that Mr. Botes brought was page 39, which is correspondence or email communication between him and Mr. Matimpe, where they were reminding each other about what happened at the inquiry. And I
And
think
what page is that?
it's page, the red number is 39.
Okay,
Yes.
yes, continue.
The email on top of this page
And that's an
is
email from Mr.
from
Portes
Mr. Botes
to
of
Mr. Mukhashwa, who was Mr. Portes was counsel for
the liquidator.
CI, for the liquidators, and Mr. Mukhashwa was PRASA's attorney.
Yes.
Yeah, so this was an email from Mr. Portes to Mr. Mukhashwa. What do you want to draw to my attention in that email?
This, firstly, in my answer to his statement, I said he's actually, Mr. Botes is actually, was actually the one who was persistent that the claims must be settled, because even before I went, the parties were discussing that, look, there's nothing more to go to arbitration for. And this email is 6 September, and he was actually just telling Mr. Mukhashwa that, and he was reminding him that about the evidence of the witnesses, all the witnesses, and also that he broke down the amount, and in page 42, he was telling Mr. Madimpe not to play cat and mouse, and because there was nothing more to discuss. And in the last paragraph, he was saying, in the event that we are successful to settle some of the claims, we should continue with the arbitration only in respect of the remainder of the claims which are still in dispute. And then he confirms the arbitrator's availability.
That email is dated 6 September 2017. Is the point you seek to make that even prior to your appointment as chairperson of the PRASA board, there were some communications between the legal team of the CIA group or the liquidators and PRASA's lawyers? Is that the point you want to make?
Yes.
Yes.
That
Okay.
obviously the PRASA lawyers were saying they will revert to you, but then the CIA people were saying, but you had your witnesses. What more? Let's try to separate where the issues cannot be settled. We then go to arbitration, knowing that we're only going in respect of where there's still disputes. But where there are no disputes, for example, with the evidence of the witnesses that I will refer to, why are we still going on arbitration? This was even before I went to PRASA. Those emails are September 2017. I think page 43 is the email of Mr. Mukhashwa to Mr. Botes, 5 September 2017, he says,
It says, I trust that we are on the same page now and that you will obtain proper and meaningful instruction from your client to dispose of all the outstanding issues in an effective and expeditious manner. We should not be seen to drag our feet and to play for time at our client's expense. We are duly bound to act in a responsible and diligent manner. We should therefore display leadership and act proactively in resolving these disputes. Is that the part you wanted to emphasize?
Yes, that's the conclusion of Mr. Botes. But I wanted to highlight an earlier email of Mr. Mukhashwa, where they were basically talking about the readiness of the arbitration and whether it should be postponed or not. This was an email that Mr. Botes was referring to. Actually, he was just saying there's no need to even be talking postponements and readiness. Why don't we settle? Because already separate the issues. Where there are disputes, we can go on arbitration on disputes. I'm trying to see page 45. I see it has my name, but it's just something, I don't know what it is.
I am going to stop you now, but if you have a last point to make it, and then I can ask you questions. Some of my questions will touch on some of the matters that you may have wanted to deal with.
Then after, the point that I want to make before I get to the gist of the issues between me and Ms. Ngoye is that I saw in Mr. Dingiswayo's statement, he says, when I arrived at PRASA, the first thing I asked about was this CIR matter. And that's not true, Chairperson. My evidence in my sworn statement and as I'm talking to you now is that that's not true. I met them before, even before Mr. Botes came into the picture with this CIR matter. I spoke to them after the board came back from Parliament, where Parliament had put us under pressure to give answers about the investigations that had been carried out at PRASA and the status. So as part of consultation, and I think Ms. Ngoye refers to it in her statement.
Yeah, Ms. Ngoye doesn't say that in the first meeting that you had with her, which Mr. Dingiswayo, I think, attended,
Yes.
Doesn't say that you raised the issue of the
CIR.
CIR claims.
Yes.
She says you raised them in the next meeting.
In the next meeting.
Yes.
So between her and Mr. Dingiswayo, there's no consistency. But the point, Chairperson, is when I met these two legal officials, it was just a general discussion about issues in PRASA, the issues that everybody knows about, the controversies at PRASA. And the parliamentary portfolio committee had asked the board to give a report about the AG's report, the irregularities which we were specifically directed to report about, things like the appointment of, I call them Werksmans, but I understand it's not the correct pronunciation, it's Workmans. But
Yeah, well, I think there are lots of people, including me, who are not always sure whether it's Workmans or Werkmans.
Yes, apparently the correct one is work months. So there were various reports about the appointment of workmans, which we were directed to take up. So just first go to Prasa and start sniffing around about CIA. We discussed about issues and we had a collegial discussion. I was meeting them for the first time. We asking them who they are, Miss Ngoye, why her surname is spelled with an E at the end. She confirmed that, no, indeed, I'm a descendant of Lillian Ngoyi, and she told me how they came about to spell.
I'm sure it's Home Affairs.
Yes, so, and also Mr. Dingizwayo, you know, we reminisced about those issues, that both of them are from great or well-known families in the history of South Africa. And we had no issues. We were happy that we were going to work together in peace.
That is the first meeting.
That's in our first meeting, even
Yes.
before Mr. Botes.
And I think the
came
first
in.
meeting was
I think it's on the 9th of November.
I think, yeah, it was on, I think Ms. Ngoye says it was on the 9th of November.
Let me confirm with my record. Yes, it's here, date.
And the second one was on the 14th.
9/11/17 at Prasa, Mathangoye, Fanny Dingiswayo, and then we were also with the then acting group legal group chief executive officer. My notes here says we talked about the appointment of Werksmans, what they should give the board with regard to the appointment of Werksmans, and then the discussions. We talked about how Werksmans was appointed according to them. We talked about the report of the public protector, as well as the report of Makhubele Huntley, and we were to continue our discussions. There was no mention of CIA because even me, I didn't know anything about it at the time. And then we adjourned our meeting that we'll have a follow-up meeting. The second meeting is on that date when, after Mr. Botes came, then I called them again because I was sitting with the group CEO. Then we discussed the report of that we were just reading, Chairperson. And in my statement, I mentioned, or not if it's not statement, in my memo, I mentioned that Ms. Ngoye appeared to have a faint idea about the insolvency inquiry. So, Chairperson, that's my first encounter.
Yes.
Then maybe I can stop here, but
Yeah,
I will elaborate.
Yeah, let's go back and start a little earlier.
Yes.
Before your appointment as chairperson of the PRASA board, you had been practicing as an advocate since 1999, is that right?
Yes.
Yes, and in October of 2017, you were interviewed by the Judicial Service Commission for appointment as a judge, is that right?
That's correct.
Was the interview on the 4th, or what was, are you able to remember the actual date? You
I
but
can't remember.
Early in October.
I can't remember of it, but it's usually first week of October.
Yeah, it's usually first week of October.
be
I
maybe
think it was first week of October.
3 or 4 October.
Yes. Now, you had been nominated for appointment as a judge as far back before October as when? In other words, when were you nominated, or when did you put in your nomination documents? Would it have been around July?
I think the closing date was Maybe July,
maybe around July.
maybe around July.
Yes, yes. I take it that at that stage you had made up your mind that you wanted to go to the bench, if you could be appointed to the bench, is that right?
Yes,
Yes. And then you had the interview, I think it was on the 4th, if I'm not mistaken, of October,
maybe
from what I've
3 or
read.
4, but
Yeah. Now, you were recommended for appointment. The JSC recommended that you be appointed as a judge, is that right?
yes.
And when did you get to know that that would be their recommendation? Was it like a day after your interview or a few days after the interview? It's
normally
usually
not,
quite
it's
soon
normal,
after the
it's normally
interviews.
not days. It will be maybe, it will be the next day.
It would be the next
It's
day.
not- it's-
That's
it
my
doesn't
experience
take-
as well.
It doesn't take long.
Yeah. No, that's my experience as well, that you either hear on the same day of the interview or you get told the following day.
Yes.
It doesn't take long. So we can take it that at least by the beginning of the following week, after the interviews, you knew that you had been recommended for appointment.
Yes.
Excuse me. And at what stage had you been approached for possible appointment as a director of the PRASA board? When you went to the interviews, had you already been approached or not yet?
It must have been, I'm trying to think about the date because I have these things in my, I have already drafted some statement to respond to this at some forum. Where, remember
Oh.
remember the JCC?
At the JCC,
The JCC is already.
has had a
It's-
meeting with you.
It's actually considering that very issue, the question
Yes.
that Chair is asking me, or where you are going to.
Yes.
Why did I go to PRASA when I had already been nominated to practice?
Yes.
For the bench. And my
Yes.
answer, Chair,
Yes.
is, I will give the date I will reduce that statement into a sworn affidavit. If, the reason I didn't-
Don't speak far from the mic,
Oh,
because
sorry.
when you speak, when you are a distance away, I
The
can't hear you.
the applications to the JSC are closed maybe 4 months before the interviews. And my recollections is the approach to serve in the PRASA board was in September.
Was in September.
Was in September.
Okay.
Yes, was in September, and definitely before the interview. Yes.
And who approached you for possible appointment to
There's
the PRASA board?
there's a neighbor of mine who obviously, if you know each other, you hear about opportunities, and then you, even among circle of friends or even family. So he was a neighbor. He said he had the Minister of Transport would be constituting interim or temporary boards because he is under pressure. I think there were some court applications for the minister to constitute permanent boards. But then apparently he wanted to constitute interim boards when he was in the process of constituting permanent boards. And then I then said, look, I've already decided that I no longer want to practice. And I want to go to the bench. I have submitted an application, and if I am successful, I will, between this and the bench, I will choose the bench. So he said, anyway, give me your CV. Then I then gave him my CV. I will, if chairperson wants this communication, because it was SMS and email,
Yes,
I
yes.
will give it to you.
Okay, no, that's fine.
I will
That
give it.
might be helpful.
I
Or
will-
maybe you can include it in your,
I will include it in
Bundle. Yeah.
my statement.
Yeah.
So I gave him my CV, and definitely before the JSC interview, and then we forgot about it.
yes.
And
Are you
then-
able to give the name of the neighbor?
It's Mr. Chauke.
Mr. Chauke?
Chauke, yes.
Yes, and what is the name?
His name is Richard.
Richard.
Richard, yes.
Mr.
He's-
Richard Chauke.
He's a doctor now. You can call him doctor.
Or is that a medical doctor,
No,
academic
the-
doctor?
The learned doctor. He's not a medical doctor.
Oh,
He's
he has a doctorate.
He's a doctorate.
Okay, no, that's fine.
I understand those are the real doctors.
Well, I'm sure the medical doctors
I mean,
will
for
contest
for
that.
the title, chairperson.
Or for the title.
The
Okay.
title belongs to those who have a PhD. I'm told that
Yeah.
the medical ones, it's a job.
Yeah.
I'm not saying anything. I'm just
Yeah,
yes. So I will
Okay.
give you the
yes,
the,
you'll just,
the
you'll,
trail
Yes.
of that correspondence
yes, okay, that would
between
be
the two of
helpful.
us. So when
Yes.
then I went for an interview, and we didn't talk again about my CV.
Yes.
But what I understood and what he said in return to the communication that I submitted my CV was that he was going to forward it to
Yes.
the department.
Yes,
And I didn't hear anything from anyone. I didn't until I think on that day was maybe 23 or 19 October. Then I just heard people saying my name was mentioned on television when they made cabinet announcement that I have been appointed in the PRASA interim board of control, and that cabinet has endorsed the names. And thereafter, then I received a call from the department. Then I indicated that for how long is this appointment? Because one other thing, Chairperson, before you, maybe that will be your next question. I don't want to, I'm not anticipating your questions, but because this issue has been raised.
yeah, it's been,
So
yeah.
I know the issues, the concerns.
yeah,
So I'm not anticipating.
yeah, no, that's fine.
Your questions.
Address it, yeah.
Yes, before I went to the interview, before I even submitted my application for judicial appointment, I had spoken to the JP and
That is Judge President Lambo.
Mlambo.
Yes.
And then in the course of our discussions, obviously, is to establish your readiness. And I think I did mention in my interview that he's the one who was persistent that I must apply, I must join, because I had been acting a lot. Then I then said to JP, at that time I was holding the position of chairperson of the Water Tribunal, that if I'm appointed, I will have to give notice to the Minister of Transport, not transport, of water and sanitation, because I cannot simply leave. There's a stage where the water tribunal collapsed because the chairperson left for a judicial appointment without notice, and then when we were appointed, obviously we re-established the tribunal. So I said, I will at least want to give notice of about 3 months. So I was very clear from the beginning that when I get the appointment, I will first have to give notice from the water tribunal, and that was our understanding. So when I accepted the interim, to serve in the interim board of PRASA, it was on that basis that anyway, I have time, that when I'm finalizing my work, other than the water tribunal, there were other matters that had been set down well into November and some into February and March of 2018, so that this thing will fall within that, because I was told it was going to be, the minister was given 4 months to constitute a permanent board. So people are always asking, where does this date of 1 April come from? Because that's the date that I had indicated I would be ready to start with my judicial appointment, chairperson. So that's how it went. So when the announcement for that the president has approved the recommendations, that came after I was already at PRAS.
I'm sorry, just repeat that sentence. I didn't hear it.
When the president made the appointment.
Yes, okay.
For-
To appoint you as a judge.
Yes, I was
Yes.
already at PRAS.
Yes.
Yes.
Because you were appointed as chairperson of PRASA
19 October,
on the 19th of October.
yes,
And the announcement by the of the decision of the president in terms of appointing various judges, new judges, it seems was made on the 2nd of November, or at least early November. Is
I
that your
think early
recollection?
November, but I
Early
was
November.
already at PRAS.
Yes, yeah,
I
you
was-
were already at
I
PRASA.
was already at PRAS.
Yes, yes.
So then when that announcement was made, then that we all starting on the 1st of January, then I then engaged the judge president.
You what?
I engaged the judge president,
Yes.
Mlambo, about it. I will provide chairperson with, because I mean, there's no longer a secret. Everything must be, whatever is available, we have to provide. I will provide our communication, because I was expecting that my appointment
Yes.
would have a date of 1 April,
Yes.
not 1 January. So JP, even before the president signed the letters of appointment, he issued a notice to the recommended candidates, of which I was one. The directive was telling us that he was congratulating us for having been recommended, and saying that usually from here the president will sign the certificate. He has asked him to sign for the 1st of January, but usually the president will take time, but even if it takes time, the appointment gets backdated to the date that he has given him. And he also was explaining some other logistics, appointment logistics. And I immediately wrote to JP by return email to say, well, I accept that you want to place me in Pretoria, and ask other questions. And then I said, but JP, with regard to the date, can I have a discussion with you? Remember, we had a discussion. I want to meet with you with regard to the effective date. And remember, Chair, by then the president had not yet signed, then according to that letter. So JP said to me in reply, Nana, I'm busy. Put your thoughts about the effective date in writing, which I did by return mail to him to say, JP, you remember we agreed that I want to start on the 1st of April for these reasons. And then we further exchanges between us, and apparently in between, maybe because of my delay in responding to him, because in one email he said I responded late. The president has already put the date of 1 April. And then we had further meetings with the JP, and until we came to the understanding that he will engage the Minister of Justice to ask the president to change that date to as I had requested. And obviously, I had to ask JP, but JP, why did you not give the president from the beginning the date? And then his reply was, no, he received many requests. Late
Don't speak away from the mic.
many requests, and then he wanted, I don't know what but the long and the short of it was that he did not communicate that date to the president at the time when he made that submission, and that's the story, Chairperson. Yes, I will provide the documents that I'm referring to from
Well, the commission does have some correspondence from the JP. It's not in the bundle, I think, because it came recently. We asked the JP for the letter asking for or recommending a deferment of your appointment, to say it must be at a later date. But we have got that letter, and then we've got a letter from Unite Behind, I think, if I'm not mistaken, that Unite Behind may have written, I don't know whether to you or to the JP, about their concerns in regard to you and PRASA. There may be a letter that you either wrote to the JP or wrote to Unite Behind. But we wanted to see the letter that went to either the minister or the president saying your appointment must be deferred.
I have that correspondence.
You have got that correspondence?
I have that correspondence.
Yes.
Because immediately Unite Behind started writing to JP Mlambo in end of January 2018. Towards end of January, they said, there's a judge, one of your judges is at PRASA, and according to the court role, we see she's also sitting in court. A judge cannot hold dual positions. And I think that's when they engaged with JP, responded to say, no, she has asked to start 1 April. I've already asked the minister to ask the president to do this. And that's where it started. I have the correspondence, the first and even the correspondence that JP sent to the minister subsequent to that. I also have, because a legal controversy developed. The controversy was whether that date of 1 April can simply be changed. And then, by then President Zuma was gone, it was President Ramaphosa. So the state legal advisors sought an opinion, which President Ramaphosa wanted, whether he lawfully he can grant that change. I have that opinion because it concerns me. They provided me with that opinion, and I did not even start on 1 April because now the controversy grew bigger and bigger and bigger, and then the president wanted to make sure that before he changes that date. So I stayed home. I'm no longer at PRASA because I resigned at PRASA. I'm no longer at PRASA. I'm no longer practicing as an advocate. And
When did you stop practicing as an advocate?
I on the end of March.
End of March,
End of
2018.
March.
2018.
2018, yes.
Okay.
Because I was still even appearing in court.
Yes.
And also doing water tribunal
Yes.
work.
Yes.
So my effective date.
Well, we after we got the JP's letter or correspondence, and we saw that what was said to the minister as the reason for the deferment was, I think, the work at Water Tribunal. The commission made contact with the Water Tribunal about the work that was to be done as well. You said there was some work to be done there.
I did some sittings at the Water
Yes.
Tribunal in the month of February, and I will give you a copy of my letter of resignation.
Yes, yes,
But
Yes.
there was work that I was doing at the Water Tribunal
yes,
on specific dates, which I will
Yes.
provide you with.
Now, if I recall correctly, the correspondence I saw seems to suggest that there was an appeal which had been heard on a number of days up to the end of 2017, but the judgment had been reserved and it was handed down later at some stage in 2018, I think mid-2018. But in terms of sittings, the correspondence suggested that the sittings were only in 2017. Would that be your recollection?
No, I will give Chairperson the details.
You could give a full account of
Yes.
what was there.
I will give you a full account of what was there
Yes, yes,
and which matters
Yes.
set on which date.
Yes.
And when the controversy arose, because it was clear I was not going to be working as a judge on the 1st of April, I then asked JP and Minister Masuta, I was writing to them to say, please tell me, am I still going to be a judge, or can I just forget about this and go back to practice? Because JP's position was that he can't risk putting me on the bench before that controversy was resolved. And I remember there was I had been, DJP Didwaba had put me in the recess role of April of 2018, but JP Mlambo said, no, I can't until that controversy is resolved. because there is that certificate of appointment, which we don't know whether it's valid or not until we hear from the president. And he can't appoint me to sit on the bench on an acting basis. So I did nothing in April. I did nothing in May. And then mid-May, then President Ramaphosa made a decision. I don't know if Chairperson has copies of the decisions.
I think I've seen at least, I don't know if it's a letter from the minister saying the president made a decision which I understand to be the effect of which I understand to be that you were going to start on the 1st of June, or you were being appointed with effect from the 1st of June.
Yes.
Of course, it's a little confusing because you had already been appointed with effect from the 1st of January.
Yes, but
And then now the letter
1st
says
of
you are
June.
being appointed like again with effect from the 1st of June. I found
well,
it confusing.
maybe what Chairperson missed is the proclamation
I'm
by
not-
the
I'm not
president. There's a proclamation that
sure. The
says,
presidential minute, I think.
presidential minute,
Yeah.
that says, I had previously appointed you with effect from 1 January. And now I'm changing that date to 1 June. And then there's the appointment certificate. Yes. So
Yes.
that's
Now,
what I say, maybe you did not see.
yes. Now, the letter that was written by the Judge President to the Minister about the deferment of your appointment certainly says, in effect, it's because of your work at the Water Tribunal that you were seeking the deferment. Is that correct?
I don't think it says so.
Or maybe I should ask,
I-
what is the reason that
I
made
haven't-
you
I
ask for
haven't-
the deferment?
I haven't seen that, Chairperson.
Oh,
I
okay.
said when I asked to defer, it was to finalize my work. I still had matters set down up to the beginning of the next year.
Yes.
And secondly, it was to resign from the Water Tribunal, give notice until 31 March. And I said, the PRASA issue is something that happened. Because I want to make it clear, Chairperson, I did not, JP Mlambo didn't give me permission to go to PRASA. No, he did not. I already said that when they said the appointment will not be longer than 4 months, I said, I can do this because anyway, I have time. So it was an economic decision, like I was still practicing, going to court, doing everything that an independent legal practitioner could do. So when the opportunity came, I said, I can do this, and then it will be finished before my due date to start with the...
I saw in, I think, your statement or letter to the Bar Council in relation to your complaint against Mr. Portas.
Yes.
I saw that you indicated that you had asked for the deferment of your appointment in order to wrap up your practice.
My practice,
is that
yes.
correct?
I have it here, let me...
Yes, I think I did see something to that effect.
Paragraph 1, I say I was a member of Pretoria Society of
It won't be,
I resigned from from membership of the bar with a view to prepare for taking up judicial appointment. My appointment would have been with effect from 1 January. However, I requested an indulgence of 4 months to wrap up my legal practice. So it was, I just generalized it.
Yes.
So, and then I say I would have commenced duties on 1 April, but the date was amended to 1 June 2018. I took oath of office as a judge on 8 June. Thank you.
Well, part of the concern I have is that in the letter to the minister asking for a deferment, the reason that is mentioned, and I assume that the JP mentioned it because that's what came from you, was your water tribunal commitments. But in this statement, it says it's wrapping up your legal practice. It says nothing about the water tribunal.
I haven't seen that letter, Chairperson.
Yes.
I,
Okay. No.
I can't comment on it.
Yes,
But,
okay.
But
Yes.
the request that I made
Yes.
was to wrap up my legal,
Your legal
practice,
practice.
including
Yeah.
the water tribunal. That's
Yes.
part of my legal practice.
Yes.
So I don't see the contradiction,
Yeah.
Chairperson.
You see it as
Yes,
the water tribunal is part of your practice.
yes.
Yeah. Okay.
I was appointed when I was not a full-time, it wasn't a full-time job. It's a chairpersonship where you are called to adjudicate matters, as and when there are matters. And and whilst you are doing any other work that comes your way as a legal practitioner. Yes.
So you say after, and I think you said you resigned from the bar with effect from the end of November, is it right? And then
Yes.
you continued practicing
Membership,
after
yes.
membership of the bar.
Because you can practice as an advocate from
Yes.
your house or anywhere.
Yes, no, no,
But
no. I understand
membership of the bar,
Yes,
I resigned.
you had resigned, yeah.
Yes.
But you, in terms of your practice,
I
you
continued.
continued, yeah.
I
At
continued.
that stage, you were no longer keeping chambers.
No, I was no longer keeping
You were
chambers.
practicing from home.
I was practicing from home.
From home.
Yes.
Of course, I guess you must have had quite some work, because if you defer your appointment as a judge from 1 January to up to
April.
end of March, it means you would be forfeiting 3 months' salary as a judge. So your practice must have been. you
Well,
must still
compared to the matters that I had already scheduled. It was worth it.
It was worth it.
It was worth it because I had court hearings.
You had court hearings.
I had court hearings even in Polokwane, High Court Pretoria. I was still consulting, and the tribunal, we are paid per sitting. And as chairperson, there's a administrative work that precedes sittings, because you are the one allocating matters. You are the one, allocation means you must have read the files and everything. So it was, and it was really not about money. It was about putting my life in order, that I want to close this chapter. I still have matters. I still have accounts to render, and I must do this. Let me defer my appointment. So I forfeited judge's salary for not just those 3 months, but because the appointment was delayed further for 5 months. So
But of course, when you,
it was no longer my choice. I was simply not in a position because I couldn't now assume duties because I was told the certificate must first be changed.
now tell me, in regard to your position as chairperson of the Water Tribunal,
Yes.
what was the notice period you were required to give? Was it 3 months or in terms of the law? Or what was the?
There's
not-
no specified notice.
There's no
period.
specified period.
I chose to give that
Yeah,
because there were a lot of outstanding matters, Chairperson, and as I said, I didn't want to disrupt the tribunal because if there's no chairperson, there's no tribunal. And at that time, there was even when it almost happened that on the 30, maybe towards the end of March, when I realized that this thing of changing the appointment date may not happen soon, I even considered withdrawing my resignation at the Water Tribunal because I wanted to go back to practice. And I think there was that attempt to withdraw. I was no longer, I thought, let me go back and withdraw my resignation and forget about this judicial appointment. Yes.
in the interview in the JSC, did they ask you when you would be available to commence your duties as a judge if you are appointed?
No,
They did not ask you about that?
no. Well,
Yes.
I've seen, again, I'm not preempting your questions, but because Judge Tukten, he wrote a judgment, and then he mentions in his judgment that did she conceal some facts from the JCC? Was there something she should have told the JCC? Definitely no one asked me anything. I mean, the record can be accessed. There were no questions that, when are you available? Can you start tomorrow, next week, or when? And my understanding, Chairperson, and you should know, and it's a fact that can be established, that there are judges who asked and were given much longer than 3 months. So it's not there's nothing untoward about someone asking to defer their appointment. It has happened. And there's nothing, as far as I know, there's no rule that you cannot ask. There's no rule that once you are recommended, there's a specific date that you must start in. And in my interactions with the Department of Justice, because we had a lot of interactions, and I will mention it in my statement, and also refer to the people that I was consulting with. The logistics of the appointment are with the head of a court, because he knows when he needs capacity. And even we attend the same interviews, Eastern Cape, the judges would be required to start a month earlier, and in another division, maybe a different date. And my understanding is the JP gives the minister a date that I want my appointees to commence on this date. And from there, it becomes an employment issue. That's the information I received, that in reality, the people doing the logistics of the appointment should be asking you, here is, when do you want to start? And then you say, no, I want to start next, when, and then you sign, there are forms to be signed for salary, for the declarations of interest and all those things. So my understanding from the information that has been provided to me is that that is allowed. And until now, I don't know, maybe the JCC, the JSC may want to do something about it, and because Unite Behind has gone as far as to suggest that once you are recommended, it means your economic activity starts. But they forget that the recommendation, as Chair has already said, it's soon after the interview. And the effective date of the appointment would be 2 months later, even if one were to take that appointment. But then who is going to support you in between?
Well, I certainly know that there have been occasions when persons who have been recommended for appointment as judges did not start or took quite some time before they started or before their appointments took effect. And I understand that some of them raised those issues in the JSC to say, although I've made myself available, I want to say that I won't be able to start like within the time that normally happens. I will talk to the head of court because I might want to make an arrangement for my practice. There have been those instances, but I don't know the details in regard to all of them. I just do know that there are some of those instances.
Yes, Chairperson. And the other thing is, I'm not aware of any prohibition that whilst you are under recommendation, let me put it that you are under recommendation, the kind of work you can or cannot do. I really don't know, because it was stretched to say I should not have gone to PRASA, but what should I have done? No one told me that you are now limited to doing this. If you have, you can't do that. I'm not aware.
You see, Judge Makhubele, part of what makes your case strange, at least to me,
Yes.
and I'm putting this to you so that you can address it, is that here is somebody who wants to be a judge. She has gone to an interview with the Judicial Service Commission. She knows that she has been recommended for appointment as a judge. She knows about her recommendation early in October. And around 19 October, she allows herself to be appointed as a chairperson of an SOE. It could have been maybe a private company, but an SOE in circumstances where she knows that in all probability she is going to be appointed, because I think we both know that once the Judicial Service Commission has recommended to, actually the Constitution says has advised the President to appoint you, almost invariably the President will appoint you. You know, there may be one or two cases that I'm aware of where there were some queries, but I don't remember anybody over the years who, in respect of whom any president was advised to appoint, to make an appointment, and did not accept the advice. So you're dealing with a situation where you are almost sure that you are going to be appointed, you'll go to the bench. It's towards the end of the year. It's maybe reasonable to think that the expectation would be that you would start early in the new year. So then the question arises, but why is she taking this PRASA appointment? Why is she taking on new responsibilities when she knows she is due soon to start her functions or her duties as a judge? Why is she taking on more responsibilities instead of reducing her responsibilities in preparation for going to the bench?
Well, Chairperson, the problem with that analysis is that there's an attempt to link the two scenarios, the non-taking up of the appointment and having gone to PRASA.
Not wanting to take on the judicial appointment, but wanting to take on a non-judicial appointment.
There's an ulterior motive, which is what is being. I don't know if I can only explain what I'm explaining, and then
Yes.
the complainants will be saying yes. The reason she did not is because she wanted to go and commit these irregularities at PRASA. But if you can separate the two issues, then you will see that they would not necessarily be linked, because suppose I had gone to PRASA and then under similar circumstances and I come out without any allegation of wrongdoing, there wouldn't be any controversy about it.
Well, to me, there would still be something strange about taking the PRASA job.
Yes.
Because, as I say, when you know that you have been recommended for appointment as a judge, and you know that soon you will be expected to commence your duties as a judge, one would expect you to begin to wrap up, because you know you are soon going to start as a judge. One would not expect you to take on more responsibilities. That's point one. Point two, these responsibilities, this was a position that would be seen as not consistent with being a judge, to say, but this person wants to be a judge, she has made a choice, she wants to be a judge, she knows she has been recommended, in due course she must start working as a judge. Why is she adding on another responsibility that has got nothing to do with judicial function?
I'm ready to answer to any suggestions that may be put as the reason, so I can, if I have to dispute the suggestions, but I have already given my how it happened. You know, Chairperson, you're sitting there with hindsight.
Yes, but I just wanted to address it again.
You're sitting there with hindsight, questioning the motives of someone who says it happened because I had time. I had time until end of March, as far as I'm concerned, and that in the period there was nothing to prevent me to have taken up the appointment. You know, if the suggestion or if what was being put to me was to say, you know, there's a prohibition that you cannot do this, then I will start to begin to say, to want to justify, to say, I did not know. But I'm saying, as far as I'm concerned, or as far as I knew, there was no prohibition, and I did that out of a need, and I'm telling you that I was still adjudicating matters at the Water Tribunal. It was not a full-time job. It was on a calling basis. And same with PRASA. It wasn't a full-time job. It was I'm already in this tribunal, and board to me would sound the same, that even there I'll go when I'm needed. There are meetings, schedules of meetings that we are given, and then that other side there's also schedule, and then there are court hearings which are also scheduled, and I did not see any besides not seeing any conflict, I did not deem it as a job that chairperson would call a huge responsibility. And I will tell you, again, I'm not anticipating the questions, because I know the questions have been asked by everyone, even at the JCC. There's a ruling that Chief Justice and his committee have already made, that of all the cases at PRASA, she concentrated on this CII matter. And I'm going to prove that I didn't concentrate on CII matters. And maybe not to you, but I'm ready to...
Yes, no, but I am going there. But let's deal with this first. I am going there.
I am going to prove that we did a lot at PRASA, and I will be happy to share what we did with you, so that you can see that there was nothing strenuous about it. I carried it, and I also carried what I had to carry at the Water Tribunal and also in court. So I am ready to answer that question, that other than CII, what did you do, Chairperson, if you want to get to it now?
Yes, no, I think we will, but let's finish on this. I'm surprised that you say you didn't see your position as chairperson of the PRASA board as a position that came with huge responsibilities. I'm surprised by that, because my own understanding is that indeed any position of chairperson of a board of any of these SOEs comes with a lot of responsibilities. But also...
Chairperson, can I correct you?
No, before that, I'll give you a chance.
Yes.
Also, purely from what one has been hearing about PRASA in the public domain, even before this commission, the allegations of corruption and what's happening there, and of course I've had some evidence within the commission, but even in the years, some years back in the public domain, it was quite clear that there were lots of allegations of corruption at PRASA. And also, you may or may not be aware that your predecessor in that position, Mr. Popo Mlefe, has testified in this commission. My understanding of his testimony is that as a board, they had a lot of work to do. So my impression is that there was quite a lot of work. It was a lot of responsibility. That's why I'm saying that I'm surprised that your evidence seems to be that, no, it wasn't such a heavy job.
Well, you misunderstood me. The word that we were using was strenuous. And I said it was not a strenuous job. I did the job very well, and I will show you what we did. Yes, there was a lot of work. And I told you the chairperson that the second day of our appointment, we were called to Parliament and we were given certain tasks to report, and we had meetings. So I didn't use the word there's no job. I said it was not strenuous. I was able to carry it. Yes.
So do you accept that the job came with a huge responsibility?
Yes, I do.
Yes.
I
yes.
do.
You see, that's in part where my difficulty is namely that here is somebody who should be winding down in order to be ready to take a new position as a judge soon. But instead of winding down, is taking on a new position with a huge responsibility. That doesn't sound, that seems strange to me.
If Chair can tell me how strange it is, and maybe tell me what informs your
Well, I think that
worry,
once you know,
because we've been on this, and I can't take it further. Chair will
Yes.
remain with the
Yes.
the impression that it's strange, and I
yes,
can't, in the absence.
you can't say anything
In
more
the
than what you've
absence
said.
of
Yes.
you telling me what you think informed my decision to enable me to deal with your thoughts, whether they are, it's just your thoughts or the evidence that has been laid before you, I can't take it any further.
No.
Can I request I need to drink water, Chair, if I can have an opportunity to just get my water and drink it?
A comfort break?
I've been talking for long now.
Yes.
Yes.
Okay, let's take a 15-minute comfort break. I see it's 7:15, so we come back at 7:30, and then we'll see how,
Yes.
when we can adjourn.
Yes, thank you.
Okay, we'll take an adjournment for 15 minutes. We'll resume at 7:30. We adjourn. It's 7:30. We'll adjourn at 8. Yes. Yes. Counsel and judge.
Oh, sorry.
Yes.
Going to start afresh. The reason I asked what issues the commission is investigating, because I obviously need to know what I'm supposed to respond to. And yesterday, I wrote a letter to Chairperson. I'm not saying you have seen it yet, but you can just take note. It's 4 August 2020, where I requested certain information. And part of that information that I requested was that I see the witnesses before you have attached the judgment of Judge Neil Tupten. And in that judgment, he has made some adverse remarks about me. And he has also, one of the issues that he is dealing with is the issue of why did I what did I possibly withheld certain information, what was I doing at PRASA, and then he makes a recommendation that he is of the firm view that a platform should be created for me to answer the questions that he has raised. Some of the questions relate to the allegations of the settlement of the claims, but then again specific to the issues pertaining to my appointment as a judge and the very strange feelings that Chairperson says you have. And then he says a platform must be created for me. So in the letter that I wrote to Chairperson yesterday, I specifically...
I haven't seen that letter.
So
it might have,
I
might be on the way.
I specifically asked if this commission is that platform that Judge Tupten has suggested must be created, or what am I supposed to answer with regard to the judgment of Judge Tupten, which has been attached to the witnesses' statements, Chairperson. So at this point, my request is that and when we started, Chair said, no, you only dealing with the issues pertaining to the settlement of the claims. And I took comfort in that. But then now Chairperson is asking me questions about...
Well, I said the issues that we'll deal with are those that are in the affidavits in this commission. And then I mentioned the settlement, which is one of them.
Yes.
And actually, it occupies quite a big part of what Ms. Ngoye and Mr. Dingiswayo talks about. One of the things that Ms. Ngoye raises is that, but the chairperson of the PRASA board had been appointed as a judge. Actually, when she took up the position, accepted the position of chairperson of the board of PRASA, she had already been recommended for appointment. She raises those issues in her affidavit.
Well, she makes statements. She doesn't raise issues.
Well, she is saying,
just
in
a
effect,
statement. The person that calls it, it's Mr. Ahmad in his statement. And I think when we deal with this evidence, I expect to address what it means by my controversial appointment. But then the issue that I'm saying, Chairperson, is in the letter that I've written, which you say you have not seen. Maybe if Chair can see the letter first, because I refer to the rules of the commission in terms of the rules of the commission, if there are proceedings in any other forum that were conducted, be it, so in this case, on these very same issues, there's a proceedings at the High Court in Pretoria before two judges, Holland Mitter and Tukten. There are proceedings before the JCC where I've already appeared, and the rule 6.5 says a witness, well, I'm obliged, and the other witnesses are obliged to bring those to your attention, those proceedings, to tell this, and so that the secretary can procure the transcripts in those proceedings, Chairperson. So
Yeah.
which is what the heading of this section of my letter says terms of reference in PRASA hearings, because I in all honesty, I need to know that what exactly am I supposed to respond to. That's why I started by referring to the affidavit of Ms. Ngoye, where she says the people she's going to talk about are people against who have been found wanting. And I emphasize that I'm not one of those persons. No one has ever found me wanting or anything. But
Well,
if
let me explain it to you so that we don't take too long on this.
yes,
You look at the terms of reference of the commission, you will see that they include that the commission must investigate acts of state capture and corruption and fraud in the public sector, including the organs of state. As I said earlier on, many people know that for years there have been all kinds of allegations of corruption at PRASA that have been in the public domain. Now, the PRASA witnesses who have come forward have testified about allegations of corruption at PRASA. They've made certain allegations against the CIA companies in terms of corruption. They have made certain allegations against Mr. Mackenzie Mabunda, who I understand from Ms. Ngoye's affidavit controls the CIA group of companies. And they say, here is something that happened here. Somebody who had been interviewed for appointment as a judge and had been recommended for appointment gets appointed to come to PRASA. And she comes to PRASA as chairperson of the board, and she shows special interest in the settlement of CIA claims. And they say, contrary to what you say you will tell me, and you said you will give details, they say there were many cases at PRASA, but she only showed interest in the CIA ones. They said there were many others. She just wanted CIA claims to be paid.
yes,
And they say she sidelined the legal department of PRASA, that is, people who have always been handling PRASA matters, legal matters internally. And they say, according to Mr. Mukhashwa, this chairperson tells Mr. Mukhashwa, don't deal with the legal department of PRASA anymore. And then they say the next thing, these matters are settled. And actually they say, when you look at the so-called settlement, it's not settlement, it's capitulation by PRASA. When you look at the amounts that the chairperson said must be paid, it's exactly the amounts that are claimed by the CIA group against PRASA. It's not a compromise or anything. And she says, we had to intervene when there was a new Minister of Transport, Dr. Blaine Zimande. We had to approach him and say, Minister, there is something wrong. There is something wrong happening. PRASA is about to lose about, I don't know whether it's 59 million, but a lot of millions because of a settlement that the chairperson has pushed through. We are against it. Please allow us intervene. And then they go to court and they say, we succeeded ultimately to stop this. They say the chairperson had no authority to settle these matters. The authority was with the head of the legal department. And they say we successfully prevented PRASA from losing a lot of money that PRASA was going to lose because of this chairperson. And they say since we succeeded, the CIR companies have never pursued these claims, this arbitration that was supposed to go on. That's what they said. So this commission is looking into that to see whether exactly what happened.
Thank you, Chair. We will obviously get to the other details. You remember we just stopped where I had talked about the reports of the commissioner, and then we then came to, we spent maybe the last hour talking about my appointment. But I'm going to deny everything that they are saying. I'm going to show you that I'm never one person that takes shortcuts. Even with the matter of Siyaya, I will deny that it's my decision. And even with this Siyaya matter, I always, or my board always involved the internal auditor. I have reports.
Internal auditor?
Yes. Mm-hmm. In every issue that we were dealing with that was required some, so there is, I will show you, Chairperson. And I think you have seen from my statement that my relationship with the legal team, not just my relationship, my board's relationship with the two incumbents of the legal unit broke down.
Why did it break down? Because as I understand the position from Ms. Ngoye, and I may be misunderstanding her evidence, but my impression is that you sidelined them when and they were against the settlement of the CIR claims because they believed that PRASA had reasonable prospects of success. And as I indicated earlier on, Mr. Dingiswayo testified that he was told by Mr. Makhubele, who was PRASA's attorney, that you had said the PRASA attorneys mustn't talk to the legal department at PRASA about the CIR claims.
Well, I will deal with it when I don't know what will happen first, maybe oral evidence or my statement, but I will deal with all that. But what I'm saying, Chairperson, is that maybe it's in their oral evidence.
It is also in the affidavits.
In the affidavit of Ms. Ngoye, she mentions...
Ms. Ngoye refers to it?
In her last paragraph, yes, she mentions that, she says, I may mention that the chairperson had been recommended as a judge, but she doesn't make any conclusions why that is relevant, Chairperson, which is why I'm asking whether there's a witness who has given evidence to say that I went, let me not say whether, because there is a witness, maybe we can talk about him, Mr. Botes, Advocate Botes. Advocate Botes is the only witness.
Well, let's leave Advocate Botes for now.
Yes.
Let's come back to Ms. Ngoye and Mr. Dingiswayo. What do you say to Mr. Dingiswayo's evidence that he was told by Mr. Mukhashwa that you had told Mr. Mukhashwa not to discuss the CIA claims with the legal department. And of course, you will have seen in Mr. Mukhashwa's affidavit that he confirms that that is true. What do you say about that?
I deny that, Chairperson. I never told Mr. Mukhashwa not to communicate with the legal services, and I think I mentioned in the problem is when there are multiple investigations, you don't know where you mentioned the issue, but I mentioned it that because at the JCC, the allegation is I terminated his mandate. But in his own statement before you, Mr. Mukhashwa doesn't say that. He says his mandate, he explains who terminated his mandate under what circumstances. So I deny, and I will deny. Anyway, I don't even have to deal with whether I terminated his mandate or not, because in his own words, I'm not the one who terminated his mandate. But the issue of communication with him, I never told anyone not to communicate with him. And as it is being said, Chairperson, it's someone saying, I was told by someone that someone told someone that someone says this.
Yes,
I never had any discussion of that nature with Mr. Mukhashwa.
But you did have meetings with
And the
him.
sequence of event with regard to the communication, Chairperson, is there's an email that I took exception to. Here is an executive is asked to explain something, to give information, because it's an information-seeking question. Can you tell me what happened here and here and here? And then he takes that question to Mr. Mukhashwa to answer. And I said, there's an email to that effect. This question, I wanted you to answer to me, because before you go and ask outsiders, you need to understand from within.
Yes, but
But that does not amount
no,
to
no,
me.
you are on another question now. But I'm still on the question of whether, on your denial that you told Mr. Mukhashwa not to discuss the CIA claims with the legal team of legal department of PRASA. Why would it just seems strange that an attorney who gets work from PRASA and who is working with the new chairperson of the board of PRASA would say to somebody in the legal department of PRASA, your chairperson said I mustn't discuss these matters with you, when in fact that is not so, and when in fact he expects or wants to get more work from this chairperson and this and PRASA.
I don't know, Chairperson, but if you were to allow me an opportunity to deal with this statement, because as I said, maybe I have not said it here to you, but we had meetings, and I will deal with what transpired in those meetings when Mr. Mukhashwa came to PRASA, and then I think it was me and Mr. Zide was still acting, and the legal team was not there. And I asked, where are they? And I was given an excuse, a reason why they are not there. And I think I say it in this statement. And then the next meeting, where where is Miss Ngoye? She's not here, she's supposed to be here. And then I'm told, I think the excuse then was, there was a bereavement at home. And so you, Chairperson, at no stage was anyone excluded or told not to come. And in any event, Chairperson, I am going to deny the version that they have put about what Mr. Mkhashwa told them, that I have told him. And if Chairperson still has a strange feeling, maybe let me answer to the specific allegations, because there is a sequence and of the meetings, what was discussed, and who was there, and what transpired later on, Chairperson. But I'm noting
The areas that I particularly want to hear what you have to say
yes,
on.
I'm noting what you are saying. and
Yes.
I will address it, Chairperson.
Now, you referred to Mr. Bottas. Mr. Bottas, you referred to the fact that he gave evidence and said you were the first one, you contacted him first
Yes.
about the CCI claims, and it's true, that's what he said in his evidence. You have said that the investigation that has been done by the investigators of the commission suggests that the probabilities are that he contacted you first, and
Yes.
he will get a chance to comment on that.
Yes, I have a statement.
One of the things he said is that in the discussion that he had with you, I think it was the first one, whether he called or you called, but that first one, he said that you said to him that you had been appointed or deployed at PRASA to clean up the mess. Do you want to comment on that?
I filed an affidavit, Chairperson.
Yes, and you deny that.
I filed an affidavit. It's part of the commission's record.
Yeah.
I have already denied,
Yes.
used the word deployed. He said, I told him I was deployed by President Zuma to PRASA, and I said, I don't even know President Zuma. I've never met him. I've never seen, I see him on TV like any ordinary South African, and I said the only time I've been within a breathing space, that's the word I used, with President Zuma is during the inauguration of Dr. Nkosazana Zuma at University of Limpopo last year, and that's the closest I've ever been. I'm not a politician. I've never been a politician. I understand the word deploy is used in those circles. But I said, I also sketched my relationship with Mr. Bottas, that I could not have discussed such things with him. We are not close, we're not friends. I don't even know what kind of work he does. He does not even know what kind of work I do. We've never been briefed by the same briefing attorneys or anything. I've never been to his. So it will be strange for me, you know, Chairperson, now when you must also understand, because throughout you kept on using the word, it's strange, it's strange. It's also strange for me when someone would make those kind of allegations to me. And you know, you get to a point when here is this allegation, and then you can only give your version. But to the mind of the next person, it will still not make sense. But he has not, I don't know if he has denied my assertions. And remember, I don't know if he came back to the commission, But I told the commission that this person I laid a complaint against, and he says it was dismissed. I said, I didn't even know it was being considered. He told you that I was invited to the disciplinary hearing. I did not attend. I don't know if he has come back to you.
Yes.
But
No, I understand that you deny what he
yes,
said.
I
but
deny
One of the
everything.
things he said, I might not remember the exact wording, but it related to what you thought of the legal department at PRASA. And if I recall correctly, he may have suggested that you said that they were undermining you or they were not good enough. I can't remember, but he says that's what you said. Do you remember that part in his?
I remember it perfectly, Chairperson. Remember, is the person that made me to want to come and testify because I thought his evidence is out of this world. He used the word, I told him, I don't trust.
You don't
the-
trust the legal
I don't trust the
department.
legal team. They want to waste PRASA's money by going to arbitration. They are undermining me. And I denied, and I think in my response, I referred to his email, the email that we read when we started, that he is the person that uses that kind of language when he talks to people. In that email that we talked about, Chairperson, he is the one who was intimidating the legal Mr. Mukhashwa and Advocate Zatawan, calling them, you are on I don't know this word, you are on the frolic of your own, and that kind of language. And you want to waste money. Why don't we settle? Why are we still going on arbitration? That's when we started, Chair, I said, even before I came in the picture, Advocate Botes was persuading the PRASA team to settle the matters. So with regard to the undermining part, I've, in the annexures, the WhatsApps and the SMSs that I say I sent, but they have not been bundled together. I have shown in one where he was telling me that the legal team and the people at PRASA, I think even the CFO, were they are undermining you. You are a person of great integrity. These people are undermining you. So he is the one who was telling me that I am being undermined.
How would you have known that they were undermining you?
Remember, he was making inquiries about the payment of the claims. The claims were settled in December, and then there was a period where it appeared there were no problems. And then the legal team said they cannot authorize the payment, which is another thing why it would be strange when the people who are going to implement the payments say they have been excluded, because everybody knows that when it goes for payment, their signature is required at some point. So I then said to Mr. Botes early in January of 2018 that, look, don't make inquiries with me, deal with, I think I actually used the word, let your attorneys handle communication because I can't help you. Then he was persistent, and then I gave him the telephone number of the new CEO, who he was then communicating with, the evidence is there, Chairperson. When we package the documents, you'll see it. Then he was communicating with the new CEO who was promising him that the claims will be paid. So it's in that context when he will be reporting to me that, no, today I've spoken to this person and this is what I said. I said, look, I am quiet because I can see that although they are not saying it out loud, I can hear in the corridors that they are making allegations that these claims should not have been settled. So I don't want to deal with this matter anymore. And that's when you would be telling me that they are undermining you. It's in that context.
Now, you say you deny that. You deny his statement that he said you told him that you did not trust the legal department of PRASA.
Yes.
Did you trust the legal department of PRASA?
I said when we started very well. We had meetings where we were going to discuss certain issues.
Go closer to the mic. Yeah.
We had meetings where we discussed certain issues, and our discussions were open. They were giving me information, and then we.
But did you trust them? That's the question.
At that stage, yes, Chairperson.
Earlier on.
Earlier on, our relationship broke down because I didn't even know they were not supporting the settlement. Our relationship broke down in after the legal panel of PRASA was suspended. There was the board.
That was on the 1st of December when it was suspended, if I recall correctly.
Yes, but then the issues came to head beginning of the year. When the Ms. Ngoye was asked to write a report to the board, and then she wrote that report, which she was not supportive of the decision. The decision had already been taken, and the report was very critical of the board. And then that her report was leaked to the media, and it was then published in some newspapers, and then it was then used by Unite Behind when they challenged the decisions of the interim board. So then that's when our relationship, not just with me, with the board, broke down. So from there,
You did not trust them after that?
Well, I had a conversation with her that, look, the report that you have written to the board, can you say something, because it's in the newspapers and it's being used by people who are challenging the decisions of the board. Can you say something so that this issue can calm down? And then she refused to. She said no, she is not willing to do that because what she has said is correct. And I wouldn't want to use the word trust, Chairperson, because I don't understand the context or the meaning of the word when you say, did I trust her or not? I'm using the word, the relationship between legal services and the board broke down. And
Yes,
then I can't say, because I never had any dealings with them after that.
Yes, you see, we talked about Mr. Porter's evidence that you told him that you did not trust PRASA's legal department.
Yes.
And you said you deny that you told him that.
Yes.
So my question arose out of that to say, did you trust them?
I said in the beginning.
So you
when-
can't say you understood what trust means when I was saying Mr. Portes said you didn't trust them, but you don't understand it.
No,
when I ask you whether you
I
trusted
said
them.
in the beginning, we had a good relationship. But then after the suspension of the legal panel, there was that discord between them and the board. And I never had any dealings with them. So I didn't use the word trust. I said we had a good relationship in the beginning. And then it broke down, not just with me, but with the entire board. Then until they were working against the board. And I have proof, I will prove to the chairperson that they were working against us. And until, because chairperson, if they had maybe, because even if it's a board that is not lawful or properly constituted, there would have been someone in the board that they would have trusted to take the problems to, but they never did. And then they were doing their things and then going behind everybody's back until the minister and until the matter is before the commission today.
So, did you involve them in discussing the merits or demerits of settling the CIA claims? Did you have a discussion with them to say, as people who had been dealing with these claims for some time as the legal department before you came, to say, let's talk about the defenses that you are putting up against these claims, and let's look at the evidence. Did you have that engagement with them before you or your board instructed that those claims be settled?
Chairperson, I've already mentioned that in the, after that first memorandum, they did not respond to it. They
did not?
They did not respond to the memorandum. They instead asked Mr. Mukhashwa to give a report. And the report that Mr. Mukhashwa was giving was about the pleadings, what they have pleaded in court. But they, and I mentioned it in my memorandum, that Ms. Ngoye appeared to have some faint, they were not aware of what was happening, if I can put it.
Yes, about the claims.
About the status of the matter, that even the insolvency inquiry, the status of the matter, when I inquired, and I say it in my statement, that when a head of and let me correct Ms. Ngoye. Ms. Ngoye does not have, she appears to think she's the litigation manager. She's the head of 3 units, LRC, Legal Risk and Compliance. The legal manager is Mr. Dingiswayo. So if they don't know the status of the matter, chairperson, and I say it in my statement when I complained about Advocate Botes, it just shows the negligent manner in which the matter was being handled. And you cannot say, in future, I intended to plead.
But remember what my question is. My question is, did you involve them? Did you engage them, the legal department, in discussing the merits and demerits of settling the CIA claims?
Chairperson, I said the answer I gave, I said I did, and they did not give me a report.
Yes.
Instead, they asked the attorney, the external attorney, to answer on their behalf. I think that's my response.
So is the position that their only involvement in regard to the process that led to the settlement of the CIA claims, was their involvement limited to the fact that you asked for a report from them about the status of the matters, and they asked the PRASA attorney to prepare a report? Is that what you are saying, or do I misunderstand what you are saying?
They asked him to prepare a report, and I said, but then I want to know from you, because yes, the attorney can prepare a report, but I don't know, Chairperson, if they have given you any report written by them to me on the matters. And before I forget, Chairperson, there's a document that I'm going to give you, which is a letter that the board directed should be written to them, to Ms. Ngoye. This is after she had gone to the minister to say, give us a report on these matters.
On the CIA claims?
Yes, on the reports on CIA, on the evidence. It was in effect asking her that since she now says the claims should not have been settled, can you please provide the board with information, reports from the people that you say are saying that testified? Remember, she's challenging. We consulted with those people, but then she says, no, she also consulted. So the board wanted her to address the merits.
You're going outside my question. Can I put it this way? From what you are saying, it seems to me that your answer is yes, the only involvement the legal department had in the process towards this that led to the settlement of the claims was when you requested a report, and they got the attorney to send a report, plus what you have added. But in terms of engaging and discussing the merits and the legal issues and why it should be the matters should be settled or should not be settled, that did not happen. Is that right?
They didn't attend the meetings.
Yes. Of course, if they don't attend the meeting, that means they did not engage.
I already said that meetings were scheduled, and only Mr. Mukhashwa came, and then and remember the reporting lines. They were reporting to the CEO.
Yeah.
And then I would be asking the CEO, but in this meeting, we're supposed to have them, and then he will give a reason why they are not there.
Yes.
And the meetings would
continue.
But they had already given that report.
Yeah.
I missed that gives, it was actually a status report to say we filed a plea, this is the plea, and
so who exactly did you involve in discussing the merits and demerits on whether to settle these claims, and if so, at what amounts?
I said in my statement, Chairperson, that there's a delegation of authority. The delegation of authority that I have, that my board was given, is attached in some documents. Mm-hmm. And I've also attached the email from the secretary transmitting that delegation of authority to the board members. And I've also said, the reason I'm saying this is because I see Ms. Ngoye has attached a delegation of authority, which I don't know. But in terms of that delegation of authority, you know, with delegated authority, there would be limits for each person or office incumbent.
Yeah.
So these, the executives, which there will be the legal manager, which is Mr. Dingiswayo, he would have his limit, financial limit. Ms. Ngoye would have his financial limit as the head, overall head of that section. The group CEO would have a limit. Then the board will have a limit. The claims were
But let,
fell within the delegated authority of a group CEO.
yeah.
So I deny that in terms of delegation of authority, it was within Ms. Ngoye's authority. In terms of the document in my possession, she did not have that kind of authority. Her authority ended somewhere, and the claims were within the delegated authority of the group CEO, not even within the, because once it gets to above million, that would be the board, but before not 1 million, 100 million.
Well, don't worry about the figures
Yes,
because we can
but the
always
point I'm
look, yeah.
making is I deny that
Yes,
it
that,
was within her authority in
Yes.
terms of the documents that were given to the board. And
Yes.
if there's any delegation of authority that she has, then she misled the board or someone misled the board, because the one that I have says what I'm telling you.
no, that's fine. But you would be aware that in her affidavit, Ms. Ngoye effectively, as I understand her evidence, says that the court rescinded the order that it had made on the basis of the arbitration awards that had been given to the CIA companies,
I don't
on the
know.
basis that you did not have authority to settle those claims because in order to settle, to have those claims settled, certain procedural steps had to be taken which had not been taken. You would have seen that in her
I haven't
affidavit.
seen that, Chairperson. I remember when I say I read her overall affidavit, there's somewhere where she says the settlement, the arbitrator set aside the settlement. I didn't get a sense that it was a
Yes.
setting aside by the court, but remember what Advocate Botes says. Advocate Botes says the PRASA did apply to set aside the settlement. The matter was set down for some time, I think.
Well,
last
this is
year.
what happened according to the evidence that has been led here.
Yes.
You instructed that the claims, you and your board instructed that the CIA claims be settled and settlement agreement or agreements, I'm not sure, were concluded. And from there, the PRASA lawyer and the CIA lawyers went to the arbitrator who was supposed to arbitrate the claims, Judge Brandt, and said, there's been a settlement, please make this settlement an arbitration award by agreement. And that was done. And then when PRASA did not pay even when that step had been taken, the CIA companies went to court to make that arbitration award an order of court. It was made an order of court. And subsequently, the legal department had to approach the court first to interdict the sheriff from paying over PRASA's money to CIA, and secondly, to rescind the order on the basis that you or your board had no authority to settle the matters. That's what she says.
No, Chairperson. Chairperson is reading the documents wrong. Let me correct you. Before, under this case number that I said there's an affidavit, yes, the awards of Judge Brand were based on the settlement. Then Judge Holland Mutter made the arbitration awards orders of court. Then PRASA went to court to interdict the sheriff, because the minute they were made orders of court, then the sheriff attached. I think it was money, not I think. Then PRASA went to court to challenge the warrants, to set aside the warrants whilst waiting to rescind the orders of acting Judge Holland Mutter. That application came before Judge Tukten. Judge Tukten rescinded the orders that made the arbitration awards orders of court. That's when Judge Tukten said the settlement is still in force, and Makhubele will have a day when there's an application to set aside the settlement agreements, because that's where I was involved. But in the meantime, if that enforcement application, you called it enforcement application, to enforce the settlement, is not, there won't be an appropriate forum, then Makhubele, there must be another forum for Makhubele to state a case. So as far as the courts are concerned, that those settlements have not been set aside. And then Advocate Botes says, the matter was set down to decide on the fate of those settlements, but then it was removed from the roll, I think last year. That's the status. So
Yes.
that's the status, Chairperson.
But you do accept
So,
that.
but then what was being said, Ms. Ngoye in her affidavit said she is going to join me when there's that application to set aside the settlement agreement. Remember, now I'm the one who acted unlawfully, and without my involvement, obviously, I mean, in those proceedings, if I decide to oppose, and I don't think I would have wanted to get involved, because I don't know, but I say in my statement, I have never been found guilty. That's what that's why I'm emphasizing that no court has ever found me guilty of anything.
What do you say about the complaint that you were running a board that did not have a quorum? That all of these things that were being done by the board was being done by a board that was not constituted in terms of the applicable act, and it had no authority to do anything until it was properly constituted. As I understand the act, and you must tell me if your understanding is different. My understanding is that your board needed to have 7 members, some of whom had to have certain expertise, but your board only had 6 members, and that the minutes will show that there was no meeting during your time, or rather, some of the minutes where meetings apparently were held show 6 members or 5 members. I don't know whether the meeting of the 16th of March, there was a new member which came. What do you say about that?
There's an application before the Western Cape High Court on that very matter, Chair. I wouldn't want to venture an answer without properly applying my mind to it. It's a legal argument that it's before court, and PRASA filed an affidavit to reply to that. I was not kept abreast. I'm
Well-
not certain if the matter, but I'm not certain if the matter has been finalized. So
Yes, no, what-
I wouldn't, I know there's an argument that was placed before court. I will have to refresh my mind about it.
Okay, no, that's fine, because we're not finishing today.
Yes.
But it's something quite important, because my own understanding is that one of the responsibilities of the chairperson of any meeting, including a board meeting, is to first satisfy themselves that there is a quorum before they can do any business, and therefore one would expect that it's
Yes.
something that you would have looked at, and probably you have a view as to whether that
Yes,
what
well,
they say is correct or not.
as I say, I believe there's a legal argument that has
Yeah.
been put. I don't want to
Yeah.
venture into it. It's quite a long time. I
Yeah.
need to read the papers.
Okay, no,
Yes.
that's fine.
And,
The last question for today, for this evening for me is, one, I talked about something that I said seemed strange to me. Another one that seems strange to me is that the so-called settlement of these CIA claims, your instruction or your board's instruction was effectively, as reflected in the settlement, was effectively that PRASA must pay exactly in regard to each of, I think, about 4 claims, the amount that was claimed, and the interest that was, the interest, I think, running from the date of service of summons. The only thing that I think wasn't there is that PRASA must pay costs. That didn't seem to me a usual settlement. In a settlement, one would normally see that the plaintiff claimed 5 million, but the actual settlement is less than that, because the parties are trying to settle so that they don't end up in court. Are you able to say anything about that?
Not at this stage, Chairperson. As
Not
I
at this
said,
stage.
when I was dealing with that report,
Yeah,
and that the evidence of, or rather the submissions of the relevant people with regard to, remember with some claims, there would have been, the issue is the amount, and then they would have indicated that the correct amount is here, and I don't want to venture an answer without looking into the documents, and but I've noted your question
yeah.
and your what makes you feel uncomfortable?
Some of this, what I consider to be, what seemed to me to be strange
be
features.
strange, yes.
Yeah.
But,
Which you might be able to explain, and once you have explained, they might not be strange.
Yes, and I may not be able to explain, but then I you know, Chairperson, remember the submissions by a person who says she is not trying to tell this commission that her quotations are correct. And she's someone who has these strange feelings about documents. And obviously, those who were there must be able to explain, Chairperson.
Yeah, no, that's
So
fine.
but at the end of the day,
It's a way of being fair to you.
Yes.
To say you must know what's
I've
weighing in my mind so that you can address it properly. you
I've
know.
seen that, and I've seen Mr. Mukhasha's response.
Yeah,
Because, when things happen in the presence of attorneys, they would know what to call the letter. Do you write without prejudice, with prejudice? It's a settlement, it's what? And it's things that happen under direction of legal advice. It's
Okay.
only lawyers who would be able to explain the wording, and I would say I relied on this explanation, but I first need to look at the document.
yeah, okay, all right. We are going to adjourn now. You must then remember that next time you must have looked at all the documents that you may wish to look at, so that we can deal with everything. But in particular, you will remember for when we resume next time that you will be among other things, you will be looking at the issue of what work you did at Water Tribunal, arising from the fact that I said the letter that the Judge President wrote to the Minister about the deferment of your appointment gave your work at the Water Tribunal as the reason.
I said I don't have that letter. Can someone?
Yes, no,
give me-
you will get the letter.
Can
The
someone
legal
give me
team-
that letter?
Yeah, that letter, as well as the correspondence from the Water Tribunal. As I said to you,
Yes.
they said there was only one appeal, but even that one appeal was only had in 2017 and not in 2018. So you can look at all of those things.
Yes.
You can also have a look and be able to say, here are cases, I don't know what they are talking about, that I was involved in. And in terms of wrapping up your legal practice, also you give us information. You said you appeared
Yes.
in certain courts,
In
what
certain
you are
courts.
able to give us.
And I will also give you what we were doing at Prasa.
Yes, yeah, do that as well.
Because of this belief that there was an obsession with the one matter. And Chairperson, if I may also say, I did indicate to you that I would also, I was reading the rules. There's if part of my response will point to irregularities. Remember, the affidavit of Ms. Ngoye says she wants to highlight where the leaders were found wanting in various reports of AGs, PP, and the National Treasurer. And Chairperson, I must say right now that she only talks about me as a person, as if I was there alone. But she doesn't talk about herself. There are irregularities involving her, Ms. Ngoye and Mr. Dingiswayo, which I'm going to talk about and require an investigation by this commission, because once I mention it, there is that obligation. She doesn't talk about the irregularities under the board of Mr. Popo Molefe, which I'm also going to talk about. She only wants to talk about me as if I'm just this branch, little branch that was put there at Prasa with just on my own, without. And she forgets about herself and the other boards that where there are irregularities that have been flagged by the Auditor General. We need to talk about everything irregularities, corruption, maladministration,